This is the Study for the Bar in Your Car podcast.
We're your hosts, Claude and Ma.
And this is episode 7 of Evidence, diving deep into the topic, Hearsay Part 2.
That's right. We're your AI guides brought to life by, well, the magic of artificial intelligence and Angela's evidence notes.
Speaking of Angela, we absolutely have to start with a big thank you. Seriously, thank you, Angela, a real-life law student, for sharing her notes on evidence. Everything we talk about today comes only from her material.
Yeah, and her notes give a little background. She's actually a dual American-British citizen.
Interesting.
And she got her first law degree over in the UK from the University of Law.
And get this, she received a full scholarship for that UK degree. That's really impressive.
It really is. A full ride is no small feat.
Now, Angela couldn't actually be here with us today.
No, she's busy catching up on some work, apparently.
And, like probably a lot of you listening, she's deep in study mode for the bar exam.
Plus, the notes mention she's a busy mom, too, which, makes you wonder.
How does she do it all? Seriously. Bar prep, work, family. Wow.
It's a lot. But not to worry, Angela should be back with us on future deep dives.
Absolutely. And if you want to reach out to her, maybe with feedback on this deep dive or questions, keeping in mind the disclaimers we'll get to later, of course.
Right, this isn't legal advice.
Exactly. You can email her at podcast@studyforthebarinyourcar.com.
That's podcast@studyforthebarinyourcar.com.
Her notes also mention she does freelance work as a law clerk.
Oh, right. So if you're an attorney or you know one who needs some, ad hoc help.
Yeah, drafting motions, complaints, appeals, writs, answers, briefs, that kind of thing.
Angela offers assistance with that. You can contact her for those freelance services.
And the email for that is hello@legalwriterandlawclerk.com.
hello@legalwriterandlawclerk.com. Got it.
Okay, so with all that covered, let's dive into the main event, Hearsay Part 2.
Right, hearsay. It's a beast, isn't it? Such a huge topic in evidence.
Definitely why we split it into 2 parts. Last time we covered the basics, the foundation. Now we build on that with Part 2.
Okay, so quick rewind just to set the stage. In Part 1, using Angela's notes, we looked at, what hearsay is fundamentally.
That core definition. An out-of-court statement offered to prove the truth of the matter asserted. We spent some time just unpacking that.
And then we jumped into things that look like hearsay, but under the rules, specifically FRE 801D, are actually defined as non-hearsay.
Right, those exclusions, like prior statements by a witness, prior inconsistent statements under oath, prior consistent statements to rebut, prior identifications.
Yeah, Angela's notes had that example, the correctional counselor picking the attacker out of photo array. That prior ID comes in as non-hearsay under 801D, as long as the counselor testifies and is subject to cross, even if they don't remember the ID on the stand.
Crucial distinction.
And the other big category of non-hearsay, statements attributable to a party opponent under 801D2. That's a big bucket.
Huge. The party's own statement, obviously, like saying, my insurance will cover it.
Or adoptive admissions, where you basically agree with someone else's statement, maybe even just by being silent when you'd normally deny it.
Authorized statements, too, and statements by agents or employees.
But with limits, right. The note stressed it had to be within the scope of the agency or employment and made during the relationship.
Exactly. That Acme Trucking example statement after firing doesn't count. The phone tech example outside their scope, it doesn't count. And for authorized statements, you need proof of the authority, like with the buyer-seller agent example.
We also touched on multiple hearsay. Hearsay within hearsay.
The nesting doll problem.
Pretty much. And the rule there, from Angela's notes, is simple but critical. Every single layer has to have its own way in. An exception or an exclusion for each level.
That police report example was good for that. The report itself might be, say, a business record, okay. But the bystander's quote, inside the report, that's layer 2. It needs its own justification. Maybe it's an excited utterance, maybe a party admission, maybe nothing.
Right. If the bystander wasn't under a business duty, their statement doesn't just ride in on the coattails of the report itself. The unavailable husband's threat, reported by the wife, classic, inadmissible, multiple hearsay if no exceptions apply.
Then we started on the Rule 803 exceptions, the ones where it doesn't matter if the declarant is available or not, like present sense impressions.
Statements describing something right as you see it, or immediately after. Spontaneity is key, the note said, even if there isn't a hard stopwatch rule.
Yeah, that example of the caller seeing men leave a truck, if there was too much uncertainty about the time gap, it wouldn't qualify.
And excited utterances. Statement about a startling event made while still under the stress or excitement from that event.
Has to relate to the event, and you have to still be, freaked out or shocked. The pedestrian hit by a car screaming, "He hit me, stop him." Perfect example from the notes.
We also briefly covered statements of mental, emotional, or physical condition, present state of mind, how you feel right now.
And statements for medical diagnosis or treatment, describing symptoms, pain, even the cause if it's for getting diagnosed or treated. Past or present condition, the notes mentioned, is fine here.
Okay, that was the speed run through part 1. Now let's really dig into the new stuff for part 2, focusing on these exceptions and concepts from Angela's outline.
All right, first up in our deep dive for part 2, based on Angela's notes, past recollection recorded. This is Rule 803.5.
This one's interesting because it comes into play specifically when another technique fails.
Exactly. You have a witness on the stand. They can't remember something important. You try to jog their memory, maybe show them a report they wrote.
Right, you try refreshing recollection first, like, does this help you remember?
But what if it doesn't? They look at their own report and still blank. That's when past recollection recorded might save the day.
Okay, so what are the requirements according to the notes? First, you need a record, a memo, a report, something written down.
And it must have been made by the witness, or they adopted it as accurate.
Second, the witness has to testify under oath that they cannot now recall the information well enough to testify fully and accurately, even after looking at the record. The refreshing attempt failed.
Third, and this is crucial, the record must have been made or adopted by the witness when the matter was fresh in their memory.
Fresh doesn't mean like 5 minutes later necessarily, but reasonably close to the event, so the memory was still reliable at the time the record was made.
And fourth, the witness has to testify that they knew the record was accurate when they made or adopted it. I wrote this down, and I knew it was right at the time.
So if you meet all those conditions, what happens? What's the effect?
This is the key difference. The record itself gets admitted as substantive evidence. It can be read into evidence for the jury.
Ah, okay. So unlike refreshing recollection, where the goal is to get the witness to testify from their revived present memory and the document usually doesn't come in.
Right. With refreshing, the document is just a tool. Unless the other side wants to offer it, it stays out.
But with past recollection recorded, the memory isn't revived. So the past accurate record becomes the evidence itself.
Angela's notes had that police officer example differentiating them. Officer reviews an interrogation transcript. If it jogs his memory and he then testifies about the interrogation based on his current recall, that's refreshing. The transcript isn't the evidence.
But if he looks at it and says, honestly, I still don't remember the details, but I know I made this transcript accurately right after the interrogation when it was fresh in my mind.
Then, assuming all requirements are met, the transcript itself can be read to the jury as past recollection recorded under 803. That distinction is huge for the bar.
Okay, moving on. Another really common one, business records. Rule 803.6.
Yes, the workhorse exception comes up all the time. The idea is that records kept in the regular course of business are generally reliable because the business itself relies on them.
Makes sense. So what does Angela's outline say are the elements?
All right, first, it has to be a record of an act, event, condition, opinion, or diagnosis. Pretty broad. It must have been made at or near the time of the event by someone with knowledge or from information transmitted by someone with knowledge.
Someone with knowledge. We'll come back to that. What else?
The record has to be kept in the course of a regularly conducted activity of a business, and business here is defined broadly. Includes organizations, institutions, professions, not just for-profit companies.
And making that kind of record has to be a regular practice of that activity. It can't be something whipped up just for litigation, usually.
Right. It has to be routine for that type of business or organization.
How do you get it admitted? How do you lay the foundation?
Two main ways, according to the notes. Testimony from the custodian of records or another qualified witness who knows the system. Or, much easier sometimes, through a certification that complies with Rule 902.11 or 12.
Self-authenticating, basically. Saves time.
Exactly. And finally, the exception applies unless the opponent can show that the source of the information or the method or circumstances of preparation indicate a lack of trustworthiness. The burden's on the opponent to show it's unreliable.
Okay, back to that someone with knowledge part. Her notes emphasize something here, right? About the source.
Yes, this is critical for multiple hearsay issues within business records. The person making the entry must either have personal knowledge themselves Or they must have received the information from someone within the business who had personal knowledge and was under a business duty to report that information accurately.
Ah, the business duty requirement. So if a secretary types up a report based on what a mechanic told her, and both work for the company and it's part of their jobs, that's probably okay.
Right. But what if the secretary includes a statement from a random bystander who saw the accident the mechanic was involved in?
The bystander isn't under a business duty to report to that company. So their statement within the business record is still hearsay.
Exactly. That inner statement from the outsider needs its own hearsay exception, like excited utterance, party admission, etc., to be admissible. The business record exception only covers the part based on information from people with a business duty.
Got it. That's a classic bar exam trap. The notes also mention police reports sometimes qualifying.
Yeah, they can sometimes fit, especially maybe in civil cases, according to the notes, but there are often specific rules or confrontation clause issues with police reports, especially in criminal cases, which we'll get to.
What about when something isn't in the record?
Good point. Rule 8037 allows the absence of an entry to prove that an event didn't happen if it was the kind of thing the business regularly recorded.
Like the example from the notes, if the medical chart shows no entry for giving medication at 2 p.m., and they always record medication administration, that absence is evidence the dose was missed.
Right. And remember that trustworthiness check, the court can still exclude a record if it looks like it was made under circumstances suggesting it's unreliable, like being prepared purely for litigation. The source also needs to be trustworthy.
The notes had some other examples too, like a corporate exec's personal diary probably wouldn't qualify because it's not a regular practice of the business activity.
Right. But a hospital record with a doctor's diagnosis usually would qualify. The key is the regularity and the business duty aspect.
And that bit about an expert relying on a doctor's letter? The letter itself isn't automatically a business record unless it meets the 83-6 requirements.
Exactly. Oh, and a quick side note from the outline. Sometimes business routines can also come in as evidence of habit under Rule 406, which is different from the hearsay exception. Okay, next up, closely related, public records and reports, Rule 8038.
Similar idea to business records, right? Reliability comes from the official duty.
Pretty much. These are records from public offices or agencies. Her notes list the main types covered, records about the agency's own activities, and things like vital statistics, birth, death, marriage records.
What are the specific requirements listed in the notes?
It needs to be a written report from a public office or official. The official must have had personal knowledge of what's being reported.
Or, if it's based on information from others, presumably those others had knowledge and a duty.
Well, the rule focuses on the official's duty. The official must have had an official duty to observe and report on the matter.
Okay. And like business records, there's a trustworthiness requirement.
Yes, the exception applies unless the source or other circumstances indicate a lack of trustworthiness. Again, the opponent usually has the burden to show it's untrustworthy.
What about police reports under this rule?
Her notes say the officer's own firsthand observations in a report like describing an accident scene are generally admissible under 8038 as observations made pursuant to duty.
But what about statements from witnesses included in the police report?
Same problem as with business records. Statements from bystanders or others who are not under an official duty to report to the police are generally not covered by the public records exception itself. That's still inner hearsay needing its own exception. Big deal in criminal cases.
Got it. So the officer writing, I saw skid marks 50 feet long. That observation might be okay under 8038. But the officer writing, bystander Jones told me the red car ran the light. Jones's statement needs a separate path in.
Precisely. The notes give the example of a fire marshal's inspection report being admissible in civil litigation under this rule.
And just like business records, there's an exception for the absence of a public record.
Yep. Rule 803. If a diligent search fails to find a record of something that the office would normally keep, that absence can be used to prove the thing didn't happen or doesn't exist. The example was jail records showing no entry for someone being booked.
Her outline also mentioned property records again.
Right. Just briefly reiterating Rules 803, 414, and 15, records of documents affecting property interests, like deeds filed in the county clerk's office, are admissible to prove the content, execution, delivery of the original recorded document.
Okay, shifting gears a bit. Learned treatises. Rule 803.18. This one involves experts, right?
Yes, this exception allows statements from authoritative books or articles to be used substantively, but only in a specific way involving an expert witness.
What are the hoops you have to jump through, according to the notes?
First, the statement has to come from a published work, a treatise, journal article, pamphlet, etc.
Okay.
Second,
The publication has to be established as a reliable authority in its field.
and how do you establish that?
Her notes say by the testimony of any expert witness, doesn't have to be the one relying on it, or the court can take judicial notice of its authoritativeness.
All right. And third,
The statement from the treatise must either be relied upon by an expert during direct examination or called to their attention during cross-examination. An expert has to be on the stand when it's brought up.
so you can use it to cross-examine an opponent's expert, like, Doctor, aren't you aware that the leading treatise in cardiology says X, which contradicts your opinion?
Exactly. Or your own expert can say, my opinion is based, in part, on this statement from this well-recognized medical text.
Now, here's the tricky part. Wasn't there something specific about how it comes into evidence?
Yes, absolutely critical point in the notes and a favorite bar question. If admitted, the statements from the treatise can only be read into evidence.
Meaning, the book or article itself does not get admitted as an exhibit that the jury can take back with them during deliberations. They just hear the relevant passage read by the lawyer or witness.
Ah, okay. The rationale being that the jury needs the expert's context to understand it properly. They shouldn't just be flipping through a dense textbook on their own.
That seems to be the idea. The expert acts as the filter and interpreter. So foundation involves getting an expert to confirm it's authoritative, and then you can use the specific statements while the expert is on the stand. Okay, now we're moving into a different category. The Rule 804 exceptions. What's the big difference with these?
The absolute prerequisite for all Rule 804 exceptions is that the declarant, the person who made the out-of-court statement, must be unavailable to testify at the current trial or hearing.
Right. Unavailability is the gateway. The notes don't detail all the ways someone can be unavailable, like privilege, refusal, lack of memory, death, illness, absence despite reasonable efforts. But you just have to know that unavailability is required for these.
Got it. So, assuming the declarant is unavailable, what's the first 804 exception listed?
Former testimony. Rule 804(b)(1).
Okay. What counts as former testimony?
Testimony given as a witness under oath at a prior trial, hearing, or even a deposition in the same or a different proceeding.
Makes sense. So you have unavailable declarant, you have prior sworn testimony. What else?
The testimony must now be offered against a party in the current case.
And here's the really crucial part of it.
You got it. That party against whom it's now offered, or in civil cases, their predecessor in interest, someone with a close legal relationship, must have had an opportunity and a similar motive to develop that testimony back in the prior proceeding.
Opportunity and similar motive. What does that mean practically?
It means they had the opportunity back then to question the witness through direct, cross, or redirect examination, and their motive for questioning them on that subject matter was fundamentally similar to the reason they'd want to question them now.
So, if in a prior deposition, the defendant's lawyer cross-examined the now unavailable witness about the very issue being disputed in the current trial, that deposition testimony might come in against the defendant.
Exactly. If the issues and the party's interest in probing those issues were similar then and now, and they had the chance to do it, the former testimony is considered reliable enough to substitute for live testimony when the witness is unavailable.
Okay, what's the next 804 exception requiring unavailability?
Statements against interest, Rule 804(b)(3).
How is this different from a statement by a party opponent under 801(d)(2)? That's also against their interest usually.
Good question. Party opponent statements under 801(d)(2) only apply if the statement is offered against a party to the case, and it's defined as non-hearsay. It doesn't require unavailability. This 804(b)(3) exception can apply to statements made by anyone, party or non-party, requires the declarant to be unavailable, and is an exception to the hearsay rule.
Ah, okay. Different rule, different requirements. So what kind of statement qualifies under 804(b)(3)?
It has to be a statement that, when made, was so contrary to the declarant's own interest that a reasonable person in their position would not have made the statement unless they believed it was true.
What kind of interest count?
The rule specifies proprietary or pecuniary interest, money or property, like admitting you owe a debt or don't own something.
Oh.
Or it had a great tendency to expose the declarant to civil or criminal liability. This is often used for third-party confessions, like someone admitting they committed the crime the defendant is charged with.
That sounds powerful. Is there any extra requirement for statements against penal interest? criminal liability.
Yes, very important point in Angela's notes. If the statement exposes the declarant to criminal liability and it's offered in a criminal case, either to exonerate or inculpate the accused, it needs to be supported by corroborating circumstances that clearly indicate its trustworthiness.
A safeguard against finger-pointing or false confessions being used too easily.
Exactly. And the notes mention this exception can apply even if the statement also happens to be a party-opponent admission. But again, the primary requirement here is unavailability and meeting the against interest standard.
Okay, the notes mention some other exceptions too. Let's run through those.
Sure. Another big one under Rule 804 requiring unavailability is statements under the belief of imminent death. Dying declarations. Rule 804(b)(2.
The classic movie scene exception.
Kind of, yeah. So, declarant must be unavailable. When is it admissible?
Her notes say it's admissible in prosecutions for homicide or in any civil case. So limited scope in criminal cases, but broader in civil.
What's the core requirement about the declarant's state of mind?
They must have made the statement while believing their own death was imminent. They have to think they're about to die.
Do they actually have to die?
Nope. Angela's notes specifically say they don't have to actually die, just believe death is imminent when they make the statement. And the statement must concern the cause or circumstances of what they believe is causing their impending death.
So, Joe shot me might qualify if said under belief of imminent death from the gunshot. But tell my wife I love her probably wouldn't, as it's not about the cause or circumstances.
Right. And the notes add it has to be based on the declarant's firsthand knowledge or perception, not just speculation.
Okay, what else under Rule 804?
Statements of personal or family history. Rule 804(b)(4). Again, declarant unavailable.
This covers statements about the declarant's own birth, adoption, marriage, ancestry, etc., or about those facts concerning another person if the declarant was related to them or closely associated with their family.
The interesting point from the notes was that for statements about the declarant's own history, they didn't necessarily need firsthand knowledge, right?
Correct. You can make an admissible statement about your own birth date under this exception, even though you obviously don't have personal memory of it.
Okay, shifting back to Rule 803 exceptions where unavailability doesn't matter, what else did the notes mention?
Market reports and commercial publications, Rule 803(17). Things like stock quotes, industry price lists, phone directories generally admissible if the public or people in that occupation rely on them.
Family records, Rule 803(13). Statements about family history found in family Bibles, engravings on rings or urns, charts, tombstones. Trustworthy because of the context.
We already mentioned records of documents affecting property interests, 803(14) and 15, as related to public records.
And finally, that catch-all, the residual exception.
Right, Rule 807. This used to be two separate rules, now combined. It's for statements that don't quite fit any other specific exception, but have equivalent circumstantial guarantees of trustworthiness.
So it's a fallback, but you need strong reasons to believe the statement is reliable. The court looks at the totality of circumstances. The notes use that letter to a boyfriend example as something that might potentially fit here if it had strong indicators of trustworthiness, even if it didn't meet another exception perfectly. Okay, this next topic is huge, especially for criminal law. The right to confront witnesses.
Absolutely. This isn't just an evidence rule. It's a constitutional right under the Sixth Amendment for criminal defendants.
What does it guarantee?
Primarily, the right to confront the witnesses against them. This usually means face-to-face confrontation in court and, crucially, the opportunity for cross-examination.
So how does this clash with hearsay? Hearsay is all about statements made outside of court.
Exactly the problem. If the prosecution offers an out-of-court statement against the defendant to prove the truth of what it asserts, the defendant doesn't get to confront or cross-examine the person who actually made that statement, the declarant, right there and then.
So does the Confrontation Clause just block all hearsay against criminal defendants?
No, it's more complicated. The Supreme Court's decision in Crawford v. Washington really changed the landscape here. Angela's notes focus on the rule that came out of Crawford and later cases. The admissibility of an out-of-court statement against a criminal defendant often hinges on whether that statement is testimonial in nature.
Testimonial. What does that mean in this context?
Her notes explain it using the primary purpose test, especially for statements made to law enforcement. Was the main reason for the interaction to address an ongoing emergency, or was it to gather evidence for a potential prosecution?
Okay, break that down. What makes a statement non-testimonial?
Non-testimonial means the primary purpose was to enable police assistance to meet an ongoing emergency. Think of a frantic 911 call during a robbery or assault. The caller is describing events as they unfold to get help right now.
The notes mention factors for determining if an emergency is ongoing, right?
Yes, things like, is the threat ongoing? Is the perpetrator still at large? What's the scope of danger? Was a weapon involved? If the main goal is resolving a present crisis, the statements made during that effort are likely non-testimonial and might be admissible without violating the confrontation clause if they also meet a hearsay exception.
And testimonial statements.
Those are statements where the primary purpose of the questioning or interaction is to establish or prove past events potentially relevant to later criminal prosecution. There's no ongoing emergency, and the focus is shifted to investigation. Think of police interviewing a witness at the station hours after a crime.
So statements made primarily to build a case for trial.
Pretty much. Angela's notes give a really important example. Forensic analysis reports, like drug lab reports.
Why are those testimonial?
Because their primary purpose, arguably their sole purpose, is to be used as evidence against a defendant in a criminal trial. They are created specifically for prosecution.
So what's the implication under the confrontation clause?
It means the defendant generally has the right to confront the analyst who prepared that report. The prosecution usually can't just admit the report as, say, a business record without making the analyst available for cross-examination at trial.
Unless the defendant forfeited the right.
Right. Her notes mention forfeiture by wrongdoing. If a defendant intentionally commits a wrongful act, like threatening or harming a witness, specifically to keep them from testifying, the defendant then loses their confrontation clause objection to that witness's prior testimonial statements being used. They can't benefit from their own wrongdoing.
Okay, that's a lot of doctrine. How does this typically play out on the bar exam, according to Angela's notes?
Well, first, the notes confirm that the MBE generally tests the Federal Rules of Evidence, FRE, not some obscure state variation.
Good to know. Any common pitfalls?
A big one mentioned is that incorrect answer choices often use old common law hearsay rules that the FRE specifically superseded. So you really need to know the current FRE rules.
Makes sense. What are the high-priority hearsay areas based on the notes?
Definitely mastering the line between actual hearsay and the Rule 801D exclusions defined as non-hearsay, especially prior statements by witnesses and statements attributable to party opponents. Understanding why they aren't hearsay is key.
What else? Knowing which exceptions require the declarant to be unavailable. Rule 804 versus those that don't. Rule 803. That's a fundamental sorting mechanism. And within those categories, knowing the specific requirements for the frequently tested ones.
Like business records and public records under 803, you mean, including those tricky multiple hearsay issues within them.
Exactly. And the requirements for excited utterances, present sense impressions, statements for medical treatment. For 804, knowing the elements of former testimony, dying declarations, and statements against interest.
That distinction between past recollection recorded, 803, and refreshing recollection, Rule 612, is also classic testing fodder, focusing on when the document itself comes in.
And absolutely, the confrontation clause analysis in criminal cases. Applying that testimonial versus non-testimonial primary purpose test is crucial.
Her notes also flagged a specific bar exam tip about the best evidence rule, right? Even though it's not strictly hearsay.
Yes, a really important clarification. The best evidence rule, or original document rule, only applies when you are trying to prove the contents of a writing, recording, or photograph.
What if you're using the writing for something else?
Then the rule doesn't apply. If you're just using a document to refresh a witness's memory, you aren't trying to prove what the document says. You're trying to help the witness remember. The rule is irrelevant there.
The notes had good examples. Proving a bank is insured doesn't require the policy itself if you have other ways to prove the fact of insurance. The officer using the transcript to refresh memory isn't trying to prove the transcript's contents per se. Don't fall for that trap if the contents aren't the point.
One more tip mentioned, crossing over into privileges but relevant for bar testing strategy. Distinguishing attorney-client privilege from work product doctrine.
Right. They often get confused. Attorney-client protects confidential communications between attorney and client for legal advice. It's about the communication itself.
Whereas work product protects materials prepared in anticipation of litigation. The lawyer's notes, thoughts, strategies from discovery by the other side. It's about protecting the litigation preparation process.
They have different scopes, different exceptions, different purposes. Knowing the difference is apparently key for avoiding wrong answers on the exam.
Wow, okay. We covered a lot of ground there in Hearsay Part 2, all based on Angela's outline.
We really did. From past recollection recorded all the way through the confrontation clause and those bar exam tips. Hopefully, breaking it down this way helps make it a bit more manageable for everyone studying.
And once again, a huge thank you to Angela for providing such comprehensive notes. We couldn't do this without them.
Absolutely. Now, just a few quick but important housekeeping items and disclaimers before we sign off, straight from the source material.
Right. First off, please remember, Angela is a law student, just like many of you. She's not presenting herself as an expert, and she hasn't passed the state bar yet.
Though her notes do mention she holds a third-year practice certificate in Virginia and is a certified legal intern in Pennsylvania, so she has some practical experience.
True, but still, as she emphasizes, she's a student, not a legal expert giving advice.
Her skills really shine in note-taking and apparently in AI, which is why we're here.
Her notes also had that interesting aside about the federal judiciary having its own separate system, including its own bar exams and admission criteria. Kind of fascinating.
It is, but back to the main point. Neither Angela nor we AI bots, Claude and Ma, are giving legal advice here. Nothing in this deep dive should be taken as legal advice.
Seriously, this is a study aid. It's not a substitute for doing your own thorough study of the law, reading cases, doing practice questions.
And related to that, AI isn't infallible. We're working from Angela's notes, but, sometimes AI can make mistakes.
Angela tries to catch any errors, but always double-check things against your primary sources.
And finally, the safety message, especially for a podcast called Study for the Bar in Your Car. Your safety is paramount. If listening to detailed evidence rules is distracting you from driving safely,
Please hit pause. Listen later when you can give your full attention without risking anything on the road.
Okay, quick reminder on contact info. For podcast feedback or questions for Angela, email podcast@studyforthebarinyourcar.com.
And if you're an attorney or no one who needs ad hoc freelance help with legal writing motions, briefs, etc., you can reach Angela about her law clerk services at hello@legalwriterandlawclerk.com.
All right, I think that covers all the points, which means...
Time for the traditional cheesy law joke, as long as it's not the one about the shark.
Oh!
Or the latter.
Definitely not. Okay, ready. Why did the lawyer bring a pencil to court?
I don't know. Why?
To draw his own conclusions.
Okay. On that note.
This is Claude and Ma, your AI bots, signing off.
We'll see you on the next episode. Keep studying.
Again, thank you.